Right, so now it's recording. Very good. So let me see. Oh, there it is. Right, so do you all see this? Where is it?
Yes.
Right, so you do see my pointer.
Yes.
Okay. Well, at least anyone else apart from Romy say okay, so I know that everyone is there.
Okay.
I don't see all of you.
Okay.
Okay, computer, such a great album by Radiohead. Right, so today is our last lesson for contract law. So I hope you enjoyed it because it was an awesome topic. Wow. I am the only one saying that. Very good. So we are still going to learn some final collocations for this topic. So, well, you know, I hope you like it. Who else is there? I don't see. Right. Very good. Yes. Collocations there. All right. Romina, can you read the first one?
Yes. To give judgment for the claimant or defendant.
So now you know it's to give judgment. All of you. Give judgment.
Judgment.
Judgment. Valentina, is this your first legal English lesson?
¿Me podrías repetir?
Have you ever had any legal English lessons in the past?
No.
Wow. Very good. So now you know, Valentina, we give judgment for the claimant or the defendant. Now you know it's collocation related to contract law, which is what we have just learned here. So this is our 8th lesson, and well, I hope you enjoy the rest of the course, Valentina. Very good. Okay, so we gave judgment for the claimant or the defendant. Which would be the expression in Spanish here? Are you a lawyer, Valentina?
In progress.
Progress. Very good. What about you, Maria? Can you tell me which could be the equivalent in Spanish for to give judgment for the claimant or defendant?
Juzgar. O resolver, fallar.
Yes, but I think fallar it's more suitable. Very good, Maria. Can you read the next one?
Yes. To extend an obligation.
Now you know you're supposed to extend it. Right. Valentina, can you read the next one? Do you see it?
Yes. So constitute consideration.
Consideration. Very good. So, do you know what is consideration? If you don't know it, it's okay because we're going to revise that topic now. So don't worry if you don't know it. Right, Romina, we're going now to go on with the importance of prepositions. Romina, can you read the first one?
Yes. To do something on someone's advice.
Read the example.
On my solicitor's advice, I decided not to sue.
Have you ever decided not to do something on someone's advice?
Yes.
Wow. Yes. Yes, I have. Someone gave me an advice, and I decided not to do something on his or her advice, and now you know it's the importance of prepositions.
Mhm.
Right. Maria, can you read the next one?
Yes, to continue to do something until certain date.
Read the example.
Okay. Your husband will be obliged to continue to support your children until they have all finished their education.
Why? But why not your wife? Sorry, now I got carried away. So now you know it's until a certain date. Now you know it's until. Valentina, do you know a lot about prepositions? If I ask you whether you liked prepositions, you probably will say no. I love them, but it's okay. Valentina, can you read the next one? Oh, sorry. It's well, you know, it aims for you to notice this preposition, to give judgment for, though that is a preposition. Can you, Valentina, can you give me examples of prepositions?
No.
You know any? It's just for you to know what is a preposition so that you don't get confused. It's not necessary for you to know, but it's just for you to know. For example, to is a preposition.
Mm-hmm.
Until there is a preposition. Which one? On, in, at. You know, that's it's the same in Spanish. So can you read the example? The next one.
I'm sorry, but the judge gave judgment for the other side.
The judge gave judgment for the other side.
Judgment.
So now you know it's to give judgment for the other side,
other
not
side.
by nor to, for. It's a little bit almost slightly similar to Spanish, so it shouldn't be a problem. Very good. Who else is there? Romina, can you read the next one?
To be under a legal obligation.
Under is another one. It's okay, don't worry. It may seem, I'm done with it. To be under a legal obligation. Do we have a similar expression in Spanish? All of you?
No, creo que no. Tener una obligación.
Bajo obligación. It doesn't exist. Bajo obligación.
No,
No, creo que no.
está obligada.
Bajo responsabilidad.
Bajo responsabilidad sí, o bajo su responsabilidad sí.
Right. So, well, it shouldn't be so hard to remember next time. Then it's okay. Very good. Romina, can you read the example?
Yes. You are under a legal obligation to carry out your obligations.
God, the book is so funny. In their obligation to carry out your obligation. Right, who else is there? Maria, can you read the next one?
An agreement between two parties.
Two parties, very good. And we do have the same expression, don't we? In Spanish, an agreement between two parties.
Yeah. Mm-hmm.
Yes, very good. Read the example, Maria.
Yes, there was a clear agreement between us that you would provide half of the finance for this project.
Very good. So now you know it's between. Another example of preposition. We have the same, in Spanish, it's the same example of a preposition as well, but I'm not sure how much it is taught. And it's not my not my interest now. Right, so you just, sorry, I'm going to see if I, this, very good. Right, so you will see this, maybe I can. Have you ever worked with a Jamboard, Valentina? Right, very good. Sorry, why am I? All right, I just sent a link for you. If you want, you can join if you want, or you can just watch here and watch me do it, do the activities here. Do you see the screen?
Yes.
Yeah.
Very good, so that I can know. I know. Very good. So this is our 8th lesson, just as before. Today is the 8th of September. Anonymous Moors has joined. Who is Anonymous Moors? My God. Very good. So Anonymous Moors is with me. So let's move on. Valentina, can you read here? Read this.
Jack and
Shelley.
Shelly are learning about case law. Estoy pronunciando re mal, perdón.
Don't worry. Law, yes.
The textbook gives them an example of an important case in English contract law.
Law, yes.
It is a case on intention, one of the 4 elements of a contract. It is a precedent case from the year 1990 concerning, me está costando más leerlo, hace mucho que no.
Right. Maria, can you go on?
Yes. Concerning whether or not a husband and wife can form an oral contract. The claimant is referred to as the plaintiff because the case is an old one. The extract is an example of the ratio of a common law contract case. The ratio is the legal reasoning that forms the law to the future. The first part of the text below is explanatory notes. The case begins with the words of the judge, Lord Justice Atkin.
Very good. So this is the extract that we are going to read, and it sounds and it looks like a lot. So, but don't worry because it's not. I think it's not. You all seem like great, like people who like reading. So let's read a lot. Okay, Ramina, can you read the assignment here? Sorry, do you all have the file? Well, were you all able to download this? This is all here on, let me just, on the classroom, on the Unit 3, the language of contract law, on Lesson 8, 8th of September, we have the guide, the PowerPoint,
Okay.
and the listening activity for you to know if you haven't downloaded it. It's just for you to do it at home, calmly, with no one to rush you.
Okay.
In the future, I hope you don't have many children around. Sorry, yes. Kids are great. Right. Yeah, they're great. It's okay.
You work
Right.
with children, so
Sorry, can you repeat?
that you work with children, so
Yes, I love
you're
them.
accustomed.
I started to work for children, so yes, I love them. Right, So you do see the text here. It's on frame number 3. Yes, sorry that I am so distracted. Okay, Romina, can you read? Can you start reading? I'm going to make it bigger for you to read the assignment.
Yes.
Okay.
Exercise 1. Read this extract from the case and answer the question that follow using a full sentence.
Well, the questions are right here. Do you see it? Do you see this?
Yes.
On frame number 5.
Yes.
I am sharing the screen, right? Yes.
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 Yes. Well, very good. So now you know we're going to read this, all of it here, and then we're going to answer here. Valentina, you do see it, right? You do understand what we're doing? Right, so let's move on. And Romina, can you start reading?
Yes. Balfour versus Balfour. Court of Appeal, 1919. The defendant was a civil servant based in Ceylon. In November 1915, he came to England with the plaintiff, his wife. They stayed in England until August 1916, when the husband's holiday period ended and he returned to Ceylon. Plaintiff, on her daughter's advice, stayed in England. The husband, before leaving, promised to give the plaintiff £30 a month until she returned to Ceylon. Later, the husband wrote saying that it would be better if they remained apart. The plaintiff sued on the promise to pay her £30 a month.
Promise.
Promise.
The same with this here, promised.
Promised. Promised.
Well, promised to pay her what?
£30 a month.
£30 a month. Well, £30 a month, it was a lot back in the day. Not now, but well. Okay, Maria, can you go on?
Yes. Sergeant J gave judgment for the plaintiff, holding that the husband was under an obligation to support his wife, as his wife and the parties had legally contracted that the extent of the obligation should be £30 a month.
Yes. Yes, so can you move on? Can you all move on to frame number 4? You have to do it here on the arrow. If Valentina wants to join, it's okay. If it doesn't, it's all right, all the same. Okay, Valentina, do you want to read number 3? Just number 3.
It's
Yes.
necessary to remember that there are agreements
Agreements.
between parties which do not result in contract with the meaning of that term in our law. The ordinary example is where two parties agree to take and walk together, or where there is an offer of or acceptance of hospitality. Nobody, nobody will suggest in ordinary circumstances that those agreements result in what we know as a contract, and one of the most usual forms of agreements which does not constitute a contract appears to me to be the
The
mm,
arrangements. Well,
which
the
are made.
arrangements which are made between husband and wife. It's okay. Very good, Valentina. Now, Romina, can you read number 4?
Yes. To my mind, those agreements, or many of them, do not result in contracts at all, even though they may be what as between other parties would constitute consideration for the agreement. Nevertheless, they contract because the parties didn't intend that they should be attended by legal consequences. To my mind, it would be of the worst possible example to how in legal obligations, which would be enforced in the courts.
Very good, Maria. Can you read the final one?
The common law does not regulate the form of agreements between spouses. Their promises are not sealed with seals and sealing wax. Their consideration is really that natural love and affection which counts for so little in these cold cards.
Very good. So now we're going to answer the questions here on frame number 5. Sorry, everyone, do you know in which court was this case heard?
It says Court of Appeal.
Court of Appeal. Where does it say that?
In the second paragraph.
The second one.
In the
was on
second
there.
line. After Balfour and versus Balfour.
Yes.
Did you see it?
No, sorry. After. Well,
the
yes.
title says Balfour versus Balfour.
Court of
And
Appeal.
then
Yes.
says Court of Appeal.
Very good. Court of Appeal. Can you write it down? Or maybe you want me to do it?
No, I can do it.
Court of Appeal. Very good. Everyone, all of you, what was Mr. Balfour's occupation at the time? Yeah. It says here, yes.
He was a civil servant based in Ceylon.
Yes.
Ceylon. Where is Ceylon? Right, yes. So do you want me to write it down, or do you want to write it down, any of you?
Yo todavía no abrí el que ves completo.
Right. We can say, and everyone, a great piece of advice is always, whoa. Sorry, my battery is failing. Right. So remember, a great piece of advice, if you're going to sit for the examination, is to sit down and say, Mr. Balfour's occupation, comma, at the time of the case was a civil servant. Or was that of a civil servant. Always answer, try to answer like this here, because that's what that's what the people, the examinators want. They want to see you answer like a robot. That of a civil servant. Very good. So tell me, all of you, why did the claimant not return to Ceylon with her husband? Here it says.
Because her doctor's advice.
On her husband was under an obligation to support and part of the legal. Sorry, I cannot find the one that says on the doctor's advice. What do you think? Where do you say it is, Maria?
I said that it says the plaintiff on her doctor's advice stayed in England.
Stayed in England.
But claimant
On her doctor's advice stayed in England.
the claimant not returned to Ceylon. Yes, was that?
Sí. Yes.
So it was claimant did not return on her doctor's advice. That would be the correct answer. On her doctor's advice.
Okay.
And if you say because, you should say because of her doctor's advice in the future, so you do know it's because of her doctor's advice.
Okay.
But the correct answer is on her doctor's
Oh.
No, but it was more like an FYI for your information. If you want to write down because of, you should say because of, because we are still working with prepositions. Wow. Of / on her doctor's advice. Very, very good. Who wrote that?
Me.
Very good. Yes. So tell me, all of you girls, what did the judge in the court of first instance decide?
That the parties are legally contract, that the extent of the obligation should be 30 pounds a month.
30 pounds a month, yes.
So was in favor of the to the plaintiff. Favor to or in favor of?
He gave judgment for the plaintiff.
Or okay, gave judgment for the plaintiff.
Or he failed for the plaintiff. Yes. Right, do you want me to write it down?
Now I'm writing.
Very good, yes.
Okay.
for the plaintiff. Yeah. What was the name of the judge in the Court of Appeal? Tell me, all of you.
Sergeant J.
No, I think it's the
Where is
first
it?
instance.
And
Sergeant
the
J
plaintiff?
was the judge of the first instance.
Sergeant J gave judgment for the plaintiff. Yes, right there. That would be an answer. Let me just highlight
Maybe
it.
it's Atkin LG.
Atkin LJ.
LJ.
Is necessary, but it doesn't say here. Well, that question is so difficult to answer because it doesn't talk a lot about who is who.
Yes. But in the la consigna, it
The
says,
assignment.
yes, the assignment, it says the case begins with the words of the Judge Lord Justice Atkin. Justice is his name?
No, justice means your lordship, your honor. It's just a way of calling the judges.
Okay.
Yes, your honor, your lordship. In Britain, they are called. They say you don't. They don't say your honor. They say your lordship. Because well, they like to appear as nobles or wow. Yes, you know. Right. So, what was the name of the judge in the Court of Appeal? Yes, I think, in my opinion, it's Sergeant J.
No, pero debe ser Atkin porque dice de apelación y este era el primero, digamos. Sergeant.
That was the Court of Appeal. Yeah. The first instance. Yes, it's.
So
where is it? Where is it? Atkin LJ is necessary. Well, let's do something that it's totally incorrect and say Atkin LJ / Sergeant J. Probably it's just me. Came to Britain, England, with a plaintiff, with his wife. Very, very good. The name of the judge is Atkin LJ. Very good. I love this way of answering a question. Excellent. Yes. Right. So if you move on to the next frame here in Barra de Marcos, on the arrow right there at the right. Sorry, Valentina, have you ever what? Oh, I'm not sure. I think she just left. Right.
Okay.
In exercise number 2, can you read the assignment, Maria?
Yes. Exercise 2, in each paragraph of the case, find a word that matches the definitions provided for you.
Well, read the first one here.
Paragraph. First, a word meaning started a legal action. The word is.
Yeah, that means the first paragraph, the second paragraph. So the first paragraph means a word starting legal action. Which is it?
Sued.
Yes.
Where is it? Sued on
the plaintiff sued.
On the promise, yes. So can you write it down?
Yes. Okay.
Sued, very, very good, yes. Romina, can you read the letter B?
A word meaning the amount of something. The
See,
word
it's within paragraph 2. A word meaning the amount of something. Where is it? Read it right here.
the obligation. No sé.
Extent.
Extent. Very, very good. Yeah, in that case, it's a little bit tricky. That's why. So can you write it down, Romina? Yes, extent.
I did it.
Okay, don't worry. Maria, can you read letter C?
A more formal word that means word.
Word in paragraph 3. Which one is it?
Term.
Yes. No.
No.
That term in our law. Yes. There are agreements between parties which do not result in contracts within the meaning of that term in our law. Yes, it is term. Excellent. Can you write it down, Maria?
Okay.
Romina, can read the next one in paragraph 4. Letter D.
A word meaning to decide in a legal way.
Word is in the paragraph 4. Did you find it, Romina? Well, okay.
I'm not sure.
I didn't.
What about you, Maria?
No, I'm not sure.
Well, in my opinion, I'm not sure. It says, to my mind, well, it would be,
says it has to be a word. No.
yes,
A
to
lot
my
of
mind,
words.
it would, yeah, let me finish.
Sorry.
To my mind, it would be of the worst possible example to hold that agreements such as this resulted in legal obligations, which could be enforced in the courts. I think that's my opinion. What about you?
Yeah, maybe.
Very good. Okay,
Yo creo
Romina,
que
can you
tendría que
write it?
ser, yo creo que tendría que ser una palabra en infinitivo, porque dice to decide.
Whoa. Starting, yes, to design a legal way. Well, my God, but we're gonna take a while.
Pongamos eso, ya está.
No, because you're right. It should be an infinitive. Other parties would constitute consideration.
To hold. To hold.
To hold.
Yes.
To hold. Very, very good. Yes, very good.
El alumno supera al maestro.
Yes. Very, very good, but be careful. Tread lightly, as they say.
It
To
was
hold.
difficult. Was difficult.
It was really difficult, yes. Yeah, you're right. Very, very good. Yes, I like it. You do get me. All right, Maria. Paragraph 5.
An
Read the
old
letter
fashioned,
E.
yes, an old-fashioned word meaning husband or wives.
Which word is it? In paragraph 5, we have the same word in Spanish.
Spouses.
Spouses. Which is the equivalent in Spanish?
Esposos.
Esposos.
No,
Mm.
that would be husbands. That's
Matrimonio.
esposos. Spouses would be cónyuges.
Ah,
Right, can you write it down, Maria?
Okay.
Because husbands are husbands and spouses are husbands or wives. Spouses.
Okay.
Right, so we're going to do a final activity and then I'll leave you be. And in this case, this is our, did you download the listening activity that is already uploaded on the classroom? We are going to listen to a girl. Can you read the assignment, Maria?
Sorry. Watch the video and fill in the gaps. A
Yes,
contract. Yes.
Read the first one.
A contract has 4 requirements for it to be considered lawful.
Da da da.
Ta 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 and ta ta ta.
Da 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 da. Right, Ramina, read the next one here.
what is disclosure?
Full disclosure, yes. Maria, read the next one.
Name any of the examples provided as equal consideration.
Ramia, the next one.
What must consider when discussing the
Yeah, sorry, let me just change a little bit. What must be considered?
what must be considered when discussing the item of value?
Item of value. And Maria, the next one.
Lawful terms and conditions help to make sure that there's no in the proposed agreements.
Proposed
Proposed agreements. Sorry.
agreements. Very good. Read the final question, Romina.
What does mutual
Sorry, do you want me, maybe I can make it bigger.
Okay.
Yes, yes. Well, I wanted her to say, what does mutual intent imply? So now you should know you should know that you're supposed to look for this word, mutual intent.
Okay.
And well, item of value and the examples of provided as consideration, and there's no da 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 in the proposed agreement. And what is full disclosure? So I'm going to change. I'm going to share now. Let me just, yes. Okay, do you see this? All of you?
Yes.
It's a video here. I'm going to play it and you're going to tell me whether you can listen to it. I think you can, but it's okay.
Why not?
Can you listen to it?
What's up, world freaks?
Yes.
Yes. Very good. I'm going to play it then.
What's up, world freaks? Welcome back to the channel and welcome back to part 2 of contracts. Now, in the last video, I ended off by saying, so you may be thinking, okay, well, what is the criteria? What are the elements needed for it to be considered a contract? And so today is the day I am going to give you those requirements, those elements, those criteria, whatever you want to call it, of a contract. Now, in order for a contract to be considered lawful or for a contract to be enforceable in law, it has to fulfill 4 requirements. And the requirements are, firstly, full disclosure, secondly, equal consideration, thirdly, lawful terms and conditions, and lastly, mutual intent or signature. Now let's go a step further and break these down. In full disclosure, we are disclosing all facts of what the contract encompasses, truthfully and completely, to avoid any misunderstandings. It has to be made clear without a doubt all this agreement comprises, as well as all the relevant circumstances and context, of course, they or you may consider applicable. Now, a consideration or equal consideration or a contractual consideration, whatever you want to call it, is just an item of value. It may be some type of service, performance, or money in general. But whatever it may be, both parties must consider it to be equal value. Here's where you want to take the time to consider if you stand to lose or gain from this contract. Because once the consideration is agreed upon, it cannot be changed. Lawful terms and conditions is where the structure is outlined, as well as the requirements and obligations of each and all parties involved in this contract. Fundamentally, this is just making sure there is no mischief in the proposed agreements. And lastly, we have mutual intent or signature. And this is, of course, one of the most important parts of the contract because it's proof that the agreement took place. This implies consensus ad ideum, as said in Latin, or meeting of the minds. Mutual intent can come in many forms, as long as it implies that both parties intended, keyword, to contract. Now, for the most part, the signature is what's mainly used, but sometimes mutual intent can be expressed as performance or the start of performance. And that's all. Those are all 4 requirements for a contract to be considered lawful or enforceable in law. And while you're here, be sure to like.
Can we hear again?
Yes. I think it's rather easy to follow, right?
Yes, but I couldn't
Right.
fill the gaps, fill all the gaps.
What's up, world freaks? Welcome back to the channel and welcome back to part 2 of contracts. Now, in the last video, I ended off by saying, so you may be thinking, okay, well, what is the criteria? What are the elements needed for it to be considered a contract? And so today is the day I am going to give you those requirements, those elements, those criteria, whatever you want to call it, of a contract. Now, in order for a contract to be considered lawful or for a contract to be enforceable in law, it has to fulfill 4 requirements. And the requirements are, firstly, full disclosure, secondly, equal consideration, thirdly, lawful terms and conditions, and lastly, mutual intent or signature. Now let's go a step further and break these down. In full disclosure, we are disclosing all facts of what the contract encompasses, truthfully and completely, to avoid any misunderstandings. It has to be made clear without a doubt all this agreement comprises, as well as all the relevant circumstances and context, of course, they or you may consider applicable. Now, a consideration or equal consideration or contractual consideration, whatever you want to call it, is just an item of value. It may be some type of service, performance, or money in general. But whatever it may be, both parties must consider it to be equal value. Here's where you want to take the time to consider if you stand to lose or gain from this contract. Because once the consideration is agreed upon, it cannot be changed. Lawful terms and conditions is where the structure is outlined, as well as the requirements and obligations of each and all parties involved in this contract. Fundamentally, this is just making sure there is no mischief in the proposed agreements. And lastly, we have mutual intent or signature. And this is, of course, one of the most important parts of the contract because it's proof that the agreement took place. This implies consensus ad ideum, as said in Latin, or meeting of the minds. Mutual intent can come in many forms, as long as it implies that both parties intended, keyword, to contract. Now, for the most part, the signature is what's mainly used, but sometimes mutual intent can be expressed as performance or the start of performance. And that's all. Those are all 4 requirements for a contract to be considered lawful or enforceable in law. And while you're here, be sure to like.
Right. So do you need to listen to it once again?
No.
No.
Very good. Okay, so I'm going to stop sharing. Then we're going to like this. Yes, right here. Right, so the video and fill in the gaps. Tell me, a contract has full requirements for it to be considered lawful. Maria, can you write down any? The first one.
The first one is full disclosure.
Full disclosure. Can you write it down?
Yes.
Full disclosure. Romina, the second one, were you able to listen to it?
Consideration.
Consideration. Can you write it down? Or maybe you want me to do it?
Yes. I.
Whoa, full disclosure. Yes, equal consideration. That's new for me. What about number 3, Maria? Were you able to listen to it?
Yes. Lawful terms and conditions.
Can you write it down?
Yes.
Lawful terms and conditions. Terms.
Lawful is
What
with
about the
L
conditions?
or
Yes. What about the final one, Romina?
Mutual intent or signature.
Signature, yes. Can you write it down? Or maybe you want me to do it?
No, okay.
Right, mutual intent or signature. Tell me, what is, Maria, what is full disclosure?
Full disclosure is to be fully open in setting the contract with no doubt.
Right, can you write it down?
Yes.
With no doubt, yes. Well, the hard one for Romina. Can you name any of the examples provided as equal consideration?
It may be some type of service, performance, or money in general.
Very good. Can you write any of them down?
Yes. No me está escribiendo, no sé por qué. What?
Right, well, maybe Maria.
Ah, ahí está, ahí está.
Right, yes. Or money in general. Very, very good. Maria, what must be considered when discussing the item of value?
I didn't hear it well. I just wrote that it cannot be changed, but I'm not sure if it's correct.
Well, okay. Romina.
I heard that both parties must consider the exchange to be equal in value.
Very, very good. The item of value must be equal in value. That's why the girl said you are supposed to offer something which has equal value for both parties. And so you do know what is to gain and to lose.
Okay.
Romina, can you write it down, your answer?
Yes.
Equal in value. Very, very good. Maria, lawful terms and conditions help to make sure that there is no what?
Mischief.
Mischief. Very, very good. Can you write it down? Right there on the blanks. Mischief is a new word for me. That's why I wanted to make focus on it.
But I'm not sure if I write it right. Mischief.
Mischief, yes. Okay, Romina, what does mutual intent imply?
It's the manifestation that each party intended to contract, usually.
Sorry, did you mutually what? Can you repeat?
Manifestation that each party intended to contract, usually expressed as
Intended to contract. Yes. Can you write it down? And that's the final one. And you can go home. And we are so punctual because it's 8 o'clock.
yes.
I hope you liked the audio. I really loved the explanation. It was new for me.
Yes, it was fine.
Yes, very good. I want you to, I make you write the answers down so that people who watch the video know if they answered correctly. That's why.
Okay.
Obviously, many of them are open to debate. So for the ones who are watching, you should know that there's no right or wrong. Except in law, there is right and wrong. Well, I thought it was funny, but it doesn't. Too much of a hard crowd. The manifestation that each party intended to contract, usually expressed as handwritten signature. Right. I thought you were actually going to say that it was it meant that it mostly means that the agreement took place. But I think yours is correct.
It says to the start of performance.
The start of performance, that's part of it. Because the girl gives a load of information. It can be, and
Yes.
most of the time it means what she says. It's actually a component of her explanation. That's why the agreement took place, and she says it deals mostly with a state of performance. And well, I hope you liked it. I'm going to stop recording now, and I'll see you again next week. Goodbye. I'm going to stop. Oh, why? Sorry, my mouse is failing.